Can a person inherit money from a deceased spouse even though the marriage was annulled? To find out, you have to read Campbell versus Thomas, but it's 19 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where normally I cover New York Court of Appeals cases and try to do it in 5 minutes or less, but this is part of a special limited series I'm doing on cases relevant to the elder law and estate planning community. This is the case of Campbell versus Thomas. The citation for this case is 73 AD 3D 103, published by the Appellate Division 2nd Department on March 16th of 2010. The issue in this case is whether a person can inherit money from a deceased spouse even though the marriage was annulled for lack of ability to consent by the deceased spouse. I'll explain all that in a few moments. The issue, the background I think that's helpful to understand this case, a couple things. First, under domestic relations law number 7, voidable marriages, a marriage is void. A marriage is a civil contract between two consenting adults. A marriage is void from the time its nullity is declared by the court if either party is found to have is incapable of consenting to the marriage for want of understanding. So a person lacks the ability to consent, doesn't understand what a marriage is, then the court can annul, which makes it a nullity, like it never happened, under domestic relations law number 7. The second thing to know is that EPTL, Estates, Powers, and Trusts Law 5-1.1, indicates that a surviving spouse can invoke what's called a right of election. So instead of, if the deceased spouse has a will, and under the will, the surviving spouse would get X, and the surviving spouse doesn't like that, the surviving spouse always has an option to invoke what's called a right of election and say, I want a third of the estate. That's what you're entitled to under EPTL 5-1.1. And EPTL 5-1.2a talks about what disqualifies a surviving spouse and defines it, and says a surviving spouse is a spouse that survives the deceased unless there has been a final decree of divorce or annulment at the time the deceased spouse died. So the lock-in time, the time that matters with respect to defining a surviving spouse, is the moment of death. If at the moment of death there has not been an annulment, then the surviving spouse is a surviving spouse. It doesn't matter that later on it's annulled. That's not what the statute says. The statute says it's defined by the moment the deceased spouse dies. And the last thing you have to know is that there's something called forfeiture by wrongdoing. That Supreme Court is not just a court of law that follows the law and the statutes and the case law. They can also act as a court of equity, can do things that are not necessarily by the statute as long as they're doing the right thing. And there's a concept in equitable law, in equity, that's called forfeiture by wrongdoing. It's an equitable principle that no one should be permitted to profit by his own fraud or to take advantage of his own wrongdoing. The wrongdoer is deemed, under this forfeiture by wrongdoing, to have forfeited the benefit that would flow from the acts of his or her own wrongdoing. So you can't take out insurance on your neighbor and then kill your neighbor and get the insurance proceeds. That would be a forfeiture by wrongdoing. You don't get that money. Okay, so what are the facts in this case? The facts are that in 2000, there was a person named Howard Thomas who had a diagnosis of terminal prostate cancer and severe Alzheimer's dementia. And he's taken care of by his daughter and another person named Nydia. His daughter decides to go on a week-long vacation, leaving Howard in the care of his caretaker, Nydia, who he's known for 25 years and has taken care of him and is aware of his diminished capacity and his dementia diagnosis. Nydia decides to take that week that the daughter goes away for vacation, and she brings Howard to the church and marries him, and then transfers a couple $100,000 from him to her. And then Howard dies. At that point, the children run to court and they try to annul the marriage. They say annul it, and they also try to probate the will that they have for Howard, which gives them all of his estate. At that point, the probate's court, the surrogate's court says, I'm going to hold off. I'm going to stay the surrogate matter until we resolve this annulment. And after a long series of events, the appellate division annuls the marriage. And then they go to surrogate's court. And at which point, Nydia comes out of the woodwork and says, hey, I want to invoke my right of election. And so here's the question. Even though the marriage has been annulled because of lack of capacity, lack of ability to consent, does Nydia still have the right of election to get 1/3 of the estate? Because EPTL defines the surviving spouse at the moment of death. And at that moment, that Howard died, the marriage was alive. It was not yet annulled. And so at that moment, she was a surviving spouse. So under the law, she gets 1/3 under the right of election. It goes to the appellate division and they say, no. We're going to invoke the equitable principle of forfeiture by wrongdoing. She only became a surviving spouse because of her overreach and undue influence over Howard. So we're going to invoke this power we have as a court of equity and say that she is deemed to have forfeited her rights that would flow from the marital relationship, including the right of elective share, because she only got that position through the wrongdoing that she perpetrated by bringing him and getting him married on his last few months of life when he didn't have the ability to consent. So she is not considered a surviving spouse only because of invocation of the forfeiture by wrongdoing principle. And that's the case of Thomas versus Campbell. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.